Hi, my name's John Fazio. If you're watching this video, then you've been served with a foreclosure complaint and you're trying to figure out what to do so that you can get your answer filed within the 35 days allotted. To start out with, I'd strongly recommend, if you're in this situation, that you hire an attorney who can assist you with representing you in your case and, more importantly, getting your answer filed properly. There's 3 reasons for this. If you try to do this on your own and you're not an attorney and you're not familiar with the court process, there's a lot of traps for the unwary. And it's very likely that you'll make some mistakes, but also that you're going to experience a lot of stress and be under a lot of pressure to do something that's pretty foreign. So hiring an attorney will cut out all the guesswork and make sure that you get your answer filed properly. Second of all, an attorney will understand the law and know which defenses to raise, which counterclaims might be available, and will make sure to properly contest all of the different allegations that would be critical for you to gain the time and to preserve all of your rights in your foreclosure case. And third, last and not least, is that when you go through the process of filing a foreclosure answer, you have to make sure that it's deemed contested in the state of New Jersey. And when you file an answer pro se, a lot of times the court administrative staff in the Office of Foreclosure who process these answers, as well as the judge's staff who look at the cases, may not take it as seriously and or may not process it as a contested case, which is critical for you getting the time and the opportunity to assert all of the necessary defenses. So for those reasons, you should try to get an attorney. But what if you don't have the ability financially to get an attorney? After all, you're already in a foreclosure situation. Well, if worse came to worse and you had to do this on your own, at least after watching this video, you should know what the proper steps are that you could take so that you could answer your own foreclosure complaint. And then if you do hire a lawyer, and they're going to assist you and get the answer filed for you, you'll have a better idea of the process they're going to go through and anything that you might be able to do to assist them in making sure that they raise the issues that are important to you. So with that being said, let's take a look at, this is just a sample foreclosure complaint here, which I've created on a Word document, which, has Joe Borrower over here as the homeowner, and which has your bank as the bank. Whoops. And this is just a generic form of complaint to give you an idea what the bank alleges and then what you have to do to respond. So here's a case where Joe Borrower is indebted to the bank, and they'll say what your original terms are of your mortgage, the principal balance and the interest rate. And if this is, you have to either admit or deny each one of these numbered allegations. That's what your answer has to contain, is an admission or denial of each one of these allegations. So usually it starts out with the original terms of your note, and then this number 2 paragraphs usually talk about the recorded mortgage. You'll notice that this mortgage was recorded through Mortgage Electronic Registration Systems, or MERS. So we'll get into what that is in a minute when we go to the answer. And then they'll also raise anything that has resulted in a modification of the original note and mortgage. So these paragraphs here talk about this borrower got a loan modification before they defaulted again, resulting in the foreclosure complaint. As you go down, you'll notice in this example, Second Market Bank (FSB) was assigned the rights from your bank, and so now you've got somebody different who you're dealing with, rather than the original party who you took out the loan with, and that'll be another numbered allegation in your complaint. then they'll describe the premises and they'll have an attachment showing which property this relates to, which you should always check, because sometimes in their haste the bank's attorneys get this wrong. Then it'll say that you failed to make some monthly payments and that there was a default, and then in paragraph, it's usually 6, 7, 8, or 9, that you failed to make the monthly payment on whatever date, here March 1, 2015, and all the payments thereafter, and that because of the default the bank's electing to accelerate. That's number paragraph 7, and on. They'll say that they've properly served you with the notice of intent to foreclose. They'll list any other liens that are against your property and demand a judgment for the amount due. Foreclosing your equity of redemption, that's what a foreclosure is. It's to resort to the collateral with the original first lien holder of the mortgage, cutting off all other rights that are junior or subordinate to theirs. And then in the second count, usually in a New Jersey foreclosure complaint, there will be a second count for possession, right? That is, they want to take over the property so that they can resell it. And then they'll demand that the costs of suit be borne by the borrower, which is usually something that is contained in the mortgage and the note. So that's your basic foreclosure complaint. So it's usually only 20 or less paragraphs that need to be answered. If we scroll down a little further, we see the exhibit for the tax reference and the description. That's an exhibit. And then there will usually be another schedule. And in this schedule, they put a list of all the people who have claims. You know, because in addition to Joe Borrower, we've got Joe Borrower's wife and or spouse, and we need to the bank is trying to make sure that they get a judgment against both parties. And then they'll list other judgments that should be foreclosed and debarred in the foreclosure case. And then the rest of this is stuff that us lawyers have to do. So the foreclosing lawyer that represents the bank will have to do what's called a certificate of diligent inquiry here, that they spoke with somebody at the bank, but usually it's going to be a servicer personnel that they actually talk to. So here it's Jane's service rep, and they're a contract management employee and coordinator of document review. And here the plaintiff's attorney is saying that they spoke to them and confirmed that all the documents are correct and that the amounts owed were certified by this person. This is a really critical thing that a lot of people that are doing their own answer miss, because this is where a lot of the magic happens if there's some problem with the bank standing or why they're entitled to foreclose, because sometimes the loan has changed hands and been passed around like a hot potato, and the person that has it now may be different, right, than who originally had it. And these are some other forms that are required that are just sort of boilerplate type forms. This one, it says they did a title search, and that's how they came up with all those junior lien holders. And then that they filed some necessary paperwork. There's also this thing, the foreclosure case information statement. For every case in New Jersey, there's a case information statement in which the parties are listed. And, you know, as attorneys, when we fill out these online, we either upload or we input this data, but you would have to do that in your answer if you're doing this on your own. So that's something to keep in mind, is that you have that requirement. Now, I want to just switch over here to the actual sample answer. So here we have a sample answer. We're going to walk through this in a minute. But before we do, I'd like to go and take a quick moment here to go through some resources that you are going to want to look at if you're going to try to do this on your own, which I don't recommend, but you know, sometimes the perfect is the enemy of the good, they say, right? And if you didn't have time to call our office or shop around and find another attorney that you liked, and you didn't get somebody on board, but you're still coming up against the deadline, you want to protect yourself and you want to fight the foreclosure, then you may be in the situation where you have no choice. You gotta do this on your own. And if you're in that situation, there's a couple of resources I'd recommend you look at. The first one here, would be Legal Services of New Jersey. Here they have the foreclosure process timeline, which I've gone over in some other videos and I'll be putting up more content about. It says that, once the complaint is filed and then served, you have 35 days to submit an answer and 60 days to request mediation. So these are important deadlines. And if you go to this site, lsnjlaw.org, and you search for the foreclosure timeline, you'll come to this page and you'll see these deadlines. So you have a little bit of a roadmap for what to do if you have to start this process on your own before you can get an attorney involved. I don't recommend it, but if you're in that situation, this is a really helpful resource that I strongly recommend you look at. It has some text down here, and it tells you what happens. Just like I'm doing in this video, it walks you through what happens each step of the way. And the pertinent issue here for us in this video today is this little section, right? So there's staff down in Trenton at the Office of Foreclosure that look at each one of these answers, and they try to determine if it's contesting or non-contesting. And what is the difference here? So if you file an answer and you admit certain things that would give the bank the right to resort to foreclosure, which is an extreme remedy, then the staff is going to say, oh, okay, this is a non-contesting answer because you're answering the complaint, but you're not saying that the bank doesn't have the right to foreclose, or more likely has some hurdles or some road bumps that they have to go through that they haven't properly demonstrated that they have the right to foreclose yet. And you're going to hold their feet to the fire and make them do those things. And it says, in a contesting answer, what must be included? So this is helpful information, right? In a contesting answer, you must include a response to each of the lender's claims. So that's paragraph by paragraph. So when you're in your answer, you number each paragraph, the same numbering as in the complaint, and you say why the claims are false if they're false, or why the claims are partially false and they go to whether the bank has the right to foreclose. Your answer should also include defenses, explanations about why you should not lose your home, and counterclaims, your complaints against the lender, claiming that the lender's actions may have violated other laws. In other words, how they violated your rights. Okay, so that's the basic hurdle when you're doing this process of working on your answer, is that you want to make sure that you properly contest the bank's ability to foreclose so that you can have the maximum benefit from fighting the foreclosure case. Now, if you go to NewJerseyCourts.gov, in the forms section, they have a little pamphlet. It's 14 pages called How to File an Answer to a Foreclosure Complaint. And a lot of people never find this document, but if you had to do this on your own, this is the Bible, right? This is really going to help. So it tells you here that it's $175 filing fee to file your answer and $250 if you have a counterclaim. So for most people, it's going to be a $250 fee to file with the court. So it says if you're the borrower and you believe that the lender does not have a right to foreclose on your property, you may file a written answer in which you present your defenses and explain the reasons why the lender is not entitled to a foreclosure judgment. And the foreclosure judgment has two parts, which is another thing that people often don't know. The first part is they have a judgment of foreclosure or judgment of possession that says they have the right to resort to the collateral for the payment of the debt. Then there's a final judgment that comes after that would include the amount that's currently owed and what the judgment is for. So it's a two-step process. All right, so they said some things that you need to know before you represent yourself in court. And the first thing they say, try to get a lawyer. The court system can be confusing, and it is a good idea to get a lawyer if you can. The law, the proofs necessary to present your case, and the procedural rules governing foreclosure cases are complex. Most likely, your opponent will be represented by a lawyer. It is recommended that you make every effort to obtain the assistance of a lawyer yourself. If you cannot afford a lawyer, you may contact the legal services program in your county to see if you qualify for legal services. Okay. The law is its own animal, right? So, and you want to, first of all, not make any mistakes, because you're going to be held to the standards of a lawyer if you do this on your own. And also, you want to be taken seriously. So if you hire somebody that's an expert or who's regularly practicing in the foreclosure area, then they're going to be able to do a much better job than you probably could, and the bank is obviously going to take them more seriously, and the court is going to show them more deference and respect. But they will appreciate it if you are doing this on your own, if you've taken the time to read through these resources, and if you do a really good job of putting your best foot forward. So this is an important matter, and I suggest that you take the time and do the research so that you can acquit yourself in the best possible manner if you decide to do this on your own or start the process on your own. They go through some of these defenses, which we've really talked about, and the different components of an answer in this little pamphlet, and they give you a step-by-step instruction, and then they do something really, really good. Well, they tell you how to mail it or bring it down to the courthouse, and they give you some checklists, including remembering the fee, right? Because you're going to need to make out a check, and you're probably, we can do this online, and you might be able to actually file this online, but it's difficult if you're not a lawyer and you don't have an account with the Judiciary. So you're probably going to want to go down to the local courthouse and go to the clerk's office, and there's usually a general equity chancery clerk where you can file the answer. They're going to send you to the accounting department, and which is in different rooms in different courthouses, and you're going to pay before they dock it and file the answer. Okay, and then here's the instructions, and here's the forms. So just like I'm going to show you how to do this in Word, as an attorney, I have my own form, right? And we do this in a professional way because this is our job, but the court will accept this form, which you can fill out in PDF and you can print it. And as to the first count, now you have to do the numbered paragraphs here. 1, denied because, 2, denied because, 3, denied because, and you can, if there's 2 is going to usually have like 2A, so you just do 2A, denied because, and you write out the reasons for each one of these things, right? And the same for the second count. And then you list your defenses. The plaintiff lacks standing to foreclose because, and again, this is not legal advice. I'm just giving you a little tutorial here on where to find these resources and what you can do and the process you would go through if you wanted to contest the complaint on your own. But we might say something as lawyers like the plaintiff lacks standing to foreclose because they have failed to establish possession of the original note, making them a holder of the negotiable instrument, and or have failed to establish a valid assignment predating the filing of the complaint, which would be necessary to establish non-holder in possession status. Okay, so when it comes to standing, there's something called the Uniform Commercial Code, and under the New Jersey version 3-301, there's different types of standing that the bank can demonstrate, and you can challenge that. This is something that was a big deal during the financial crisis, but is less so today. But it's still important to raise, and there's other defenses that are regularly raised by attorneys that you can raise. Okay, and then there's some certifications, and the certification of mailing. You got to send this to the lawyer. In this case, it was in the one that I showed you, foreclosure lawyer, and they had an address and everything. So let's just quickly go back to that so you can see what I'm talking about. So in our little sample and complaint, 1 second. Yeah, so we had, okay. So in our sample complaint here, which I'm pulling up now, we had, there we go. So in our sample complaint, if we go all the way back to the beginning, right? We have Bank Lawyers LLC, 100 Foreclosure Road, Bankville, New Jersey. Okay. You're going to have to tell the court that you served them with your answer by mail and certify to that in order that you're able to meet the requirements of the filing of the answer. So you don't just have to file with the court, but you also have to serve it on your adversary. Very important, because that's one of those things that if you don't do it, it may not be accepted, right? So we want to make sure we do that. All right, and then here we get to the meat and potatoes of this video, even though it's been a little bit, which is the walkthrough of the answer. So let's do that for the next couple of minutes. And so here's a contesting answer, separate affirmative defenses and counterclaims for Joe Borrower and Mrs. Borrower. So in the first count here, and this is just an example, you say one of the three. So what are your options here? Let's just do that too. Since you're not a lawyer, how do you answer these allegations, these different sections? What do you write? What do you do? What is the way that you're supposed to present your answer? Well, there's three things that you can do on any given allegation. There's three different options that you've got. The first thing you can say is that you admit it. You probably don't want to do that, right? Because if you're admitting something, then you're saying that the bank has the right to foreclose, and then it's not going to be a contesting answer, and then you're not going to get all the time that you would otherwise get, and you're not going to get to assert your rights. So we don't like that one, right? That one's not good. We can deny it, but when you deny it, you don't just say denied. You've got to also explain why. And then the other thing that you can do is you can say that you lack knowledge or information sufficient to form a belief as to the truth or falsity of the allegations contained in that count. So what does that look like? Or when is that appropriate? That's appropriate if they're talking about, like, we assigned your mortgage on such and such date, and you go, well, I don't know, did you? Or I'm looking at the documents, I see some problems, but I actually lack information about that. I need to do some discovery and find out what's going on. Or if they say the amount owed as of this date was such and such amount, and you go, I don't know, that might not have been the case. I need to look into that some more. So that's where you use that one. And there's a fourth one, very important one, number 4, that you really can use in a lot of places in a foreclosure answer, and that one is that the allegation is a legal conclusion for which no response is required. So if they say something like the bank has possession of the note and mortgage in the complaint, that's a legal conclusion, right? They have to tell you they have it and this is where it is, and they have to establish a factual foundation for that allegation. They can't just say it. If you could just say things like so-and-so is negligent, and then you get a judgment, that would be really nice, right? But that's not how this works. But they will say those types of things. They'll say you defaulted on this date, and they won't give any underlying, they won't put any meat on the bones. So this here, okay, is the New Jersey court rules, which is, these are the rules that govern the courts, and you can look these up too. And this one is 4:5-3, answer defenses form of denials. And it says this. It says, an answer shall state in short and plain terms the pleader's defenses to each claim asserted. So that's number by number. And shall admit or deny the allegations upon which the adversary relies. And then it goes on to say, a pleader who is without knowledge or information sufficient to form belief as to the truth of the allegations shall so state. And except as otherwise provided, this shall have the effect of a denial. But it doesn't automatically constitute a denial in foreclosure actions, which are under Title 46, which is the real property law. Denial shall fairly meet the substance of the allegations denied. What does that mean? That means if they say that the date of the default was March of 2015, you should say, no, we were still paying in March of 2015, and we paid up until the bank stopped taking our payments in, October of 2017. And then it says, a pleader who intends in good faith to deny only a part of or a qualification of an allegation shall specify so much of it as is true and material and deny only the remainder. The pleader may not generally deny all of the allegations and shall make denials as specific denials of designated allegations or paragraphs. All right, so that's legal speak, but while we're here, I'd like to go through a couple other self-help resources real quick. So New Jersey Courts has a site, and it has a section, self-help resources. And it tells you how you can upload documents, submit evidence online, etc. And if you do a search here in the bar, for foreclosure answer, okay, and you're going to get that package of how to file a foreclosure answer. And then if you look at all the forms that have to do with foreclosure, you're going to see this document, which is the FCIS, which along with your answer, you have to complete this document. And it's got the caption, it's got your property address, what you're filing, which is an answer. Okay, there's different types of cases. So yours is going to be a residential mortgage foreclosure, right? And the street address of the property. You're going to need your block and lot. That's going to be in the complaint. And the sign off. Okay, you're going to need that. And then we'll keep this rule open because we may refer back to it as we go through the answer. And now we go back to the answer. All right. So I hope this is helpful. We won't go through this in copious detail because this is already almost like a half-hour video. But I will go through it again in great detail in another video. We're just going to give it a once-over here. So here is the stuff about your original loan. You might not remember, so you could say you lack information and belief, or you could admit that one. And again, this is not legal advice, but those are the options. You're not going to probably deny you took out a loan. And then you may want to admit or deny some of the things about the mortgage and the note, the original mortgage and note. But then when they get down to the chain of title, you have to, so this one was the loan modification agreement. This is one where, you could admit, you could look at the loan modification agreement in your files and see if it matches, and if it doesn't, you could deny it and explain, or say that you don't have information belief because you maybe don't have the records and you need to go through the case a little bit and find out. When you get to the assignments, this is something that has a lot of legal weight, right? So in this sample answer, we said the MERS signatory as agent only has such authority as is derived from the principal, and a vice president MERS may only assign the rights of their principal. Here, your bank, if a valid paternity exists, vesting such authority in the agent. So we're saying that they are claiming that this assignment was entered by this third party, Mortgage Electronic Recording Systems, and that they haven't established that they had agency and the power of attorney necessary, giving them authority to file such a document to transfer the loan to this new party, and that you haven't seen that documentation and you contest that. Okay, here's another one where they had another assignment, and we're saying in here in response that that assignment was not valid, and that recording alone is not dispositive of the authenticity and validity of the instrument. So then there's more stuff about assignments. Now, when you get down to the default paragraphs, which were 6 through 8, we have here defendant denies the allegations and leaves the plaintiff to his proofs, and denies their right to make an election or declaration respecting the mortgage, including the right to accelerate and demand payment in full. We deny that you failed to make the payment on March 1, 2021. Deny that there was a default. If you have information and you do hire an attorney, you should give them the information showing, hey, we made payments through this date. We have information that we sent emails and letters and made calls to the servicer asking them to take a partial payment or whatever the case may be. And you can put that kind of detail in here. Judges would love to see that kind of detail, because a lot of times people are in a rush and they answer these things and they don't give the court a roadmap of where the case is going. And even as attorneys, we have difficulty getting enough information at the outset to do that. But that's what the judge's staff really wants to see, so they can determine what they're going to do with this case and what kind of track to put it on. So here we have defendant denies the plaintiff has a right to possession of the mortgage premises. Plaintiff can't demonstrate standing to foreclose by way of possession of the original note and or a proper assignment predating the filing of the complaint. That's kind of the language that I was going through when I was just playing around with the online form. And then this is the stuff about notices. Defendant denies that all the notices were sent properly. All right, so you're going to deny all these different things. We're not going to go through the second count, which is duplicative, a lot of the first. But then you got your defenses, okay? So what is an affirmative defense? So for this, we're going to take a quick second and we're going to go back to the court rules, because I know everyone finds these riveting, right? And affirmative defenses, here you go. A responsibility shall set forth specifically and separately a statement of facts constituting avoidance or affirmative defense, including but not limited to accord and satisfaction, arbitration and award, contributory and negative. So this statute actually, if you look it up online, it gives you a bunch of things that are affirmative defenses that you can plead. So you want to, if those apply, you want to put those in. So like accord and satisfaction means like a modification would be that. That would be one example. Okay, discharge and bankruptcy. If it's a second mortgage, that might be applicable. Estoppel, this is an equitable thing that would be applicable if some promises were made that induced you to take certain action and they weren't lived up to. Fraud, this is a hard one, but sometimes this is pled in foreclosures because of various different reasons. Impossibility of performance, that could be something that applies because of COVID. Okay, laches. Some of these banks, you might have a loan from 2006 and you got behind, especially second mortgages, and they waited forever to come after you and they slept on their rights, so you could plead laches. Statute of limitations. This is always a hot button issue. The statute of limitations in New Jersey on foreclosures just changed from 20 years to 6. So that's giving people who have really recent loans that are after 2019 some additional defenses. And then we're going to go back to our answer as we kind of wrap things up and bring this in for a landing. So back to our answer. Here we go. Let's see. Just make sure this is tracking. Yep. All right, so now back on the answer. So you have here an affirmative defense that the claims barred because plaintiff lacks standing or is not a real party in interest. So what you're saying here is this loan got passed around, and for various different legal reasons, you're questioning whether the bank has the right to foreclose against you. If they've established all the bona fides of how they came into possession of the loan and why they're the one that's allowed to foreclose. Now here's some defenses under the Fair Foreclosure Act. These might be applicable, they might not. One of the requirements is the notice of intent to foreclose, giving you some time to cure 30 days before they start the foreclosure process. Another thing that comes into play here is 12 CFR 102441. Those are the federal regulations under Dodd-Frank that servicers have to comply with. And a lot of the notices you get in the mail and a lot of the things where, they tell you they're reviewing your loss mitigation documents are all under those statutes, under the state and federal law. So you can fight the bank on whether or not they complied with all of those things. And that might give you a defense because they have to give you a fair chance to save your home. And if they haven't done that, that could be a defense. Third defense, alleged no mortgage was transferred out of the originator of the loan and not duly assigned or transferred. So this really harkens back to the standing argument again. The amount plaintiff claims being correct. This alone is not going to make it a contesting answer because that's something that could be dealt with at the final judgment stage. So be careful if that's your whole answer is just based on, the amounts are wrong. The judge is not going to find that to be contesting the right to foreclose. This is stuff about the certificate of diligent inquiry. This is an important thing. Plaintiff's loan servicer claims they have got personal knowledge of the underlying documents and they know that the authority over the loan was in the hands of the plaintiff when it was supposed to be. This is stuff that you should attack in the answer, put it in your affirmative defenses, and it might even be in your counterclaims depending on what happened. For instance, one of the things that I like to tell the court in a lot of cases is, hey, judge, this loan got transferred and the servicer or the new lender didn't have all their ducks in order, and they didn't have their ducks in a row. They didn't have all the paperwork in order, and they didn't have the legal authority to foreclose. They didn't have the legal rights in the debt. And so if they didn't have the legal rights in the debt, and that would defeat their ability to foreclose, they also didn't have the ability to give these loss mitigation alternatives to the borrower and put them into a tough spot because they should have been reviewed and these things should have been quickly dealt with. But maybe the reason why the bank isn't processing loss mitigation and isn't giving alternatives to foreclosure is because they don't actually have the bona fide rights in the loan, and they're waiting to go through this process to make sure the court is going to backstop them and say that they are allowed to foreclose. And that's not fair. That's not acting in good faith if they don't present those options and if they don't have the authority to grant the relief that would come with those options. All right, so we got all kinds of affirmative defenses, and then we get the counterclaims, right? And so you could have a breach of contract if there was a loan modification and they didn't honor it, or you made the trial payments and then they didn't give you the final loan, or they sold the loan right after the modification was finalized and the new party didn't honor the terms of the loan modification. So that's a good one if you had a loan modification. Unjust enrichment. This could be something where the bank, for some reason, and there could be various ones, is going to be unjustly enriched by going through foreclosure. And that could be because they weren't acting in good faith in giving you these loss mitigation alternatives. They ran the interest up or something of that nature. Okay, consumer fraud. This is a juicy one, but doesn't apply in most cases. Very hard to prove. This is where they lead you down the garden path and they make false promises. And they tell you, like back in the financial crisis, it was, you're going to be able to refinance in 2 years, but a lot of people weren't able to. Common law fraud, again, this is a very high standard. So don't plead this if you don't have like a real good reason. But that's another one. Violations of Fair Foreclosure Act. You may or may not actually have what they call a private right of action here. But if they haven't followed the proper procedures, it still might be good to allege this and let the court know what they did wrong and how it impacted you and how it deprived you of due process. Because the court can always grant relief on due process grounds. And the foreclosure court, the general equity part, is a court that has equitable jurisdiction over the parties, and they can right wrongs that have to do with fairness. So if you've been unfairly treated, even if it doesn't fit into one of the normal causes of action, you could fashion a statement of the mistreatment, and whether you do it as formally as we have here or not, explain how your rights, how they ran roughshod over your rights and how your rights were violated and what those rights are, and the court might be able to help you with some relief on an equitable basis, even if it can't do so on a strictly legal basis. There's no right to a jury in the foreclosure part because it's general equity jurisdiction. But you might make a jury demand if you have some civil claims that might get severed. For instance, if you have a fraud claim, designation of trial counsel, demand for statement of damages. Okay, this is a practice point that lawyers use. 4:18-2 allows you to request copies of your note, mortgage, and all the assignments and everything, because a lot of times they're not going to be attached to the complaint, and they're supposed to provide that to you within 5 days. So this demand for production under 4:18-2 is a very good thing to include in every answer. And you can also demand their insurance policies if you're going after them for money damages. So this is just a very simple, quick run through of a normal, everyday contesting answer, affirmative defense, and counterclaims in a foreclosure action. I hope that that is helpful and that you now know where you can go to get the resources if, God forbid, you've got to try your own, you've got to defend your own case and your house is going into foreclosure. And I hope that you got my message that you should call around and talk to different attorneys. Obviously, we'd be happy to speak with you and go over all of your options. But if you can get an attorney on board that is familiar with the correct legal practices and the practices in this area, you're going to do so much better in the long run. And I highly, highly recommend that you do everything you can to find an attorney that fits your budget and your personality, somebody that you can work with, who will explain everything to you and who will guide you through the process. In some of my other videos, I point out that the statistics that we have are that 94% of homeowners facing foreclosure don't file an answer to the foreclosure complaint within the 35 days, and they allow default to be entered and a default judgment against them. And that very much limits their ability to defend themselves and makes it harder to save their home. And it's befuddling to me why, while I understand that this is complex and there's a lot to this, why people wouldn't take the steps over something so important to get an answer in with the court, because you're going to gain 6 to 18 months by doing that, and you're going to present all the things where you feel your rights are violated and at least get the judge to hear you out on what you feel was unfair treatment by the bank. So I strongly, strongly urge you that you will be able to find a lawyer who will be able to help you for the budget that you can afford and who will have the temperament and experience that matches what you're looking for. And not all lawyers are created equal, and we all have a different approach, right? So what the approach that I take might be great for some people and might not be the right fit for others. But there are so many lawyers out there that would love to help you out, and only 6% of the people who get served with a complaint actually respond. And I think if nothing else, as members of the bar that practice in this area, we want to get the word out that, well, from a practical standpoint, the best thing you can do is work something out with the lender and not have to go to the mats on a litigation when your back is up against the wall and you do have a complaint that you've just been served with, and you're in that very emotional state where you're having a hard time figuring out what to do. Sometimes it's so overwhelming that you don't know how you're going to do anything about it, but you should take action. You should take that first step. And if you have had your rights violated, or if the bank hasn't given you the opportunity to be evaluated for loss mitigation, you should put a wrench in the gears, right? And slow down what they're trying to do, because you do have rights and they do have to honor those rights, and you should assert these rights in court and make them prove that they have the right to do what they want to do, and give them a reason and create some leverage for you to speak with them about your case. I'm not saying that you should make things up or you should be overly aggressive and come out swinging, but I'm more than sure that anybody who's watching this video, who's in this situation, who's been dealing with a bank for years and has gotten to the point where a foreclosure complaint is filed has some things that they can raise that would help them to get the bank to listen and help the judge to understand how they got to this point and what the bank did wrong that contributed to the situation that you find yourself in. And that if nothing else, having asserted your rights is going to put you in a stronger position to get a good outcome on the case, because you're going to gain the time and you're going to be taken seriously and you're going to have a full hearing of what happened to you, which is going to improve your chances of success dramatically. All right, guys, I hope that was helpful. We will have more information on how to answer the foreclosure complaint coming up in different videos. And I will organize this so that it's very clear for everyone and provide some additional resources on our website. But I'm sorry you're going through this difficult situation, but there is light at the end of the tunnel, and it starts with answering the foreclosure complaint. Thanks so much.